whether the legislative party in the House acts independently of the political party. Because I will, Malaj, while I go through the facts before your lordships, indicate to your lordships that on the 21st of June, when the first meeting took place, and we called, the group led by Uddhav Thackeray called members of the legislative party who belonged to now the Eknath Shinde group to come and attend the meeting, which was not done, pursuant to which some actions were taken. The contention throughout has been that there is a split in the party. So the issue before your lordships is, can members of the legislature within the House or comprising of those members of the House by themselves say that there is a split in the party because they don't agree with the leadership? This in turn would require your lordships to look at the 10th schedule and in that context interpret the role of the party within the legislature. Because after all, members of the legislature of any particular party get elected on a symbol of the party. They are there because of the party. And if they are there because of the party, Malaj, there is an umbilical cord link between them while they are sitting in the House and the party outside. Can that link be severed and say, we are an independent set of people, we can do what we like? That will require, Malaj, the interpretation of the 10th schedule. It requires your lordships to analyze the role of the whip, how a whip gets appointed, how he happens to be a bridge between the legislative party and the political party, and that nothing happens in the House without the political party taking a decision. Nothing happens. Well, the bill is introduced by the Treasury benches, any bill.
So is it your contention, therefore, Mr. Sibal, therefore, that unless there is a split outside the House,
yes,
within the political party,
yes,
that split cannot find recognition within the legislative party within the House? That's your...
Absolutely. That's my contention. That's the law also, Mullah, and I'll demonstrate that to your lordship. That is the law. Well, what happens, Mullah, that I'm giving your lordships an example, Mullah. A bill is introduced by the Treasury benches, a controversial bill, let's assume. Bill there in which there is no consensus. Mullah, what happens? The parliamentary party, a group of members of the legislature are invited by the parliamentary party to sit outside the House in a particular room and say, this is the bill that's being introduced, what should be our position? The party decides the position and it's articulated in the House. The legislative party by itself, dehors the party, doesn't decide what we are going to do, what you are not going to do. When a whip is going to be issued, Malad, it's issued outside the House, translated inside the House. Okay, on this, you're going to vote against the bill that has been introduced, or that you will vote in favor, or that you will abstain.
But when the 10th schedule speaks about, say, a merger, for instance, now,
yes,
there are very few exceptions in the 10th schedule, and it speaks of a merger.
Yes.
Ultimately, the speaker has to decide whether there is a merger. The speaker will not go into whether there was a merger outside the House, because then the speaker will be taking over the function of the Election Commission of India.
That argument is entirely on a different plane, Malad. So we're not dealing with it, and we'll interpret the paragraph 4 for your lordships also.
The speaker's remit cannot lie outside the House.
Malad, there's a problem. Supposing, all right, then let's analyze that for a minute, Malad, since your lordships have raised the issue. Malad, supposing there are 10 members of the legislative party in the House. The merger has to take place of the political party. They belong, say, to the Malads, to the Samajwadi Party. Right, Malads? Now, even paragraph 4 says that there's a merger of the political party, not the merger of the legislative party.
Right.
Right? So, therefore, Samajwadi Party has to merge.
But no, if we accept your argument, that would mean that unless the Election Commission of India decides on a merger outside the House, the speaker cannot take a decision within the House.
Election commission did not
whether there is a merger or not. That can't be.
No, Election Commission did not decide this issue, Malas.
How else?
Because a resolution will be passed that we have merged. And that will be informed. The election commission, they don't have to take a decision. They'll be informed. Majority of the members of the party will decide. They'll be informed. Once merger takes place, these eight people may say, we don't want to merge. And paragraph 4 says they need not merge. But I'll come to that later. This is a very complex issue. Actually, not so.
Let's have a broad now framework of the facts, because
I will, Malaj.
In fact, that was our basic problem there. Unless we have a clear perception on the facts, it's very
it.
difficult for us then to look at the law divorced from the facts.
I entirely agree. But just, Malaj, may I just, your lordship, what are the issues that are going to be? I just told your lordships too.
We have to necessarily reframe the issues, because the kind of the issues which are there, which are
yeah, it's not reflective of Malaj what needs to be decided. I agree entirely. Malaj, the other issue is, and that's never come up before the court. And that issue is, can a governor swear in a member of a legislative party against whom a disqualification matter is pending before the House? That's the other issue. Never come up before. What then are the powers of the governor in matters in relation to disqualification? This is not a case of a pre-poll alliance. This is not a case of a post-poll alliance. This is not a case of one political party. It is a case of people who allege that they are the party because they are a majority in the legislature. Right, Malaj? What then are the powers, or what should be the function of the governor in matters of this nature? And how he should conduct himself. Because he also knows, because the disqualification petition is pending, Malaj. He also knows. And if the governor does, Malaj, swear him in as a chief minister, Malaj, he actually topples a democratically elected government and aids in doing that. Because they happen to be majority in the legislature. Well, that's one of the issues that your lordships may have to consider. The other issue to be considered is, can a court, constitutional court, without referring the matter to the speaker in the facts and circumstances of this case, decide the matter on its own, given the fact that there are no disputed facts? We are not going to, Malaj, place before your lordships any disputed fact. All are matters of record.
Your question is, can a constitutional court decide 10 schedule?
That's correct.
10 schedule.
Yeah, that's correct. That's correct. Because under the 10th schedule, it has the speaker to decide, Malaj. But if the proceedings, Malaj, are imbued with illegality, and given the conduct of speakers in the past, what then should be the attitude of the court in a given matter? And then, of course, lastly, Malaj, how do you deal with an issue? And that, Malaj, because the last question in the reference is the powers of the election commission. And your lordships, and that's the last question, which is the last issue your lordships will have to decide, that under paragraph 15 of the symbols order, when there is a split in the political party, it starts with that proposition that two factions have arisen pursuant to a split in the political party. Then which faction should get the symbol?
Will that arise in this case?
I'm sorry?
Will that arise here?
Yes. That's a question. That's a question. What is the role of the election commission in matters that's part of the reference.
So under paragraph 15 of the symbols order, when two factions emerge in pursuance of a split.
Yes.
So what is the sequitur? How would you end the sentence?
Well, then what is the role of the election commission in deciding that matter? Should it await the decision of the Constitutional Court? Should it go ahead? Your lordships only, Malaj, as your lordships will remember, in September said no stay. But your lordship did not say how he is going to decide it.
But that, Mr. Sibal, is your independent challenge to the order of the election commission.
That's a separate issue, Malaj.
We can't really decide.
No, that's part of the reference, Malaj. I'm going to argue, Malaj.
How do we...
Constitutionally, the election commission cannot proceed. Malaj, the split would have to happen on 21st of June. There was no whisper of a split on
Is
21st
that
of
your
May.
contention that therefore the election commission itself cannot proceed until
Yes.
the speaker has decided?
Correct. That's what your lordship said. No stay, fine, Malaf. No stay. We went before the election commission and said, you cannot decide this matter. The matter is pending in Supreme Court. He said, no, but Supreme Court said no stay. And you will find that tomorrow, Malaf, when your lordship sit at 3:30. But that's the last question that your lordships, your ladyship will have to look at. So these broadly, Malaf, are the issues that you might be asked upon to decide, Malaf, that you might wish to decide. Now, Malaf, let's go to the list of dates, because unless you have the facts, Malaf, it will be A, whether notice for removal of a speaker restricts him from continuing with disqualification proceedings under the 10th schedule of the Constitution as held by this court in Nabia. Malaf, I've already argued that. So the lordships, Malaf, have deferred your lordship's judgment on that. So we'll skip that for the moment. B, whether a petition under Article 226 or 32 lies inviting a decision on a disqualification petition by the High Court or the Supreme Court, as the case may be. That's the question that I have already formulated in different, the language is somewhat different, but the intent is the same. Then C, can a court hold that a member is deemed to be disqualified by virtue of his or her actions absent a decision to the speaker? Actually, B and C are together, Malaj. D, Malaj, what is the status of proceedings in the House during the pendency of disqualification petitions against the members? Malaj, it really doesn't clarify what it means. What is the status of proceedings? What it means is that can members against whom there is a disqualification petition pending have a role to play in the House while it is pending? Otherwise, you can topple any government you want. Then E, Malaj, if the decision of a speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? Now, Malaj, this question only arises if you allow proceedings to go on. If you don't decide on the disqualification before, then this question arises, because if at a later point in time, you consider them to be disqualified relating back to the date when their act led to a voluntary giving up membership of the party or violation of the whip, then what happens to the intervening proceedings? A government has been formed, actions have been taken, policy decisions have been made. Would it not be better, for the purposes of, I personally believe, democratic traditions, that you should await your hands till the disqualification is decided first, because this problem will not arise then. Then, Malaj, F, I think is very, very important. What is the impact of the removal of paragraph 3 in the 10th schedule? According to me, that's central to the entire issue. Because now you don't have a split. The issue of a split doesn't arise. Which is why, if you want to go to the election commission, there has to be a split in the party, not a split in the legislature. That is not on record. No such split. So this is central, and we'll interpret paragraph 4 also in that context. Then G, what is the scope of the power of the speaker to determine the whip and the leader of the House legislative power? What is the interplay of the same with respect to the provisions of the 10th schedule? Well, it's actually, again, convoluted in its expression. In simple terms, it means that how is a whip appointed and how is a leader in the House appointed? Is there a role of a political party, or is it something that the legislative party decides? Can majority of the legislative party members decide, I'll change the whip tomorrow? So what has happened in this case, and I'll come to the facts, Mullahs, that sitting outside the House, X number of people said, you are no longer the whip. And those are members of the legislature only. Mullahs, I can give your lordships documents to the effect. What happens is, when a leader of the House is appointed, the letter that is given to the speaker is that the party hereby decides that this person will lead the House for the party. It's not the members of the legislature don't decide these issues. Similarly, whip. Because the whip is the bridge between between government or the opposition, whichever party it is, and the House, members of the legislature. That's why your lordships will see that nowhere in the constitution does the word political party is referred to, except in the 10th schedule. Because in the constitution, you're dealing with institutions. You're dealing with an institutional framework within which all political parties function. In the 10th schedule, you're dealing with framework within which a legislative party functions in the context of the political party, resulting in disqualification.